nascent thoughts and ideas along with IQAC, Kerala. Myself, Manupriya Chalan, along with my co-anchors, Akshara Dean and Miri Rojosi, will be the student moderators for this session, and we take the privilege to welcome each and everyone present virtually.
Thank you, Manupriya. It's a moment of great privilege and honor for me to extend a hearty welcome to everyone present on this virtual desk. The Kerala Law Academy Law College, a premier law college established in 1966, is a seat of excellence in legal education, consultancy, research, and pioneering law reform. Academy has been fostering many legal minds who have gone to become upstanding citizens and an integral part of legal communities around the world. To keep up with their legacy, we take the privilege to host the 14th International Seminar.
Before we start the session, I take this opportunity to remember late Dr. N.Narayanan sir, former director, Kerala Law Academy, torchbearer of our institution.
Thank you, everyone. As humans extend their reach in outer space, laws regulating human activities in that area are becoming more and more applicable and significant for both states and the commercial sector. Property rights form a legal and economic basis to support investment and provide a structure for the allocation and management of resources. As space technology and its implementation advanced, property rights to external space resources will rise in relevance.
It is necessary to enact and harmonize domestic space laws in order to create a safe environment for space exploration in the sense of legislative structure, and it should be acknowledged that there is a clear need to find a balance between the need for treaties to be amended and reformed and the protection of issues that are evidently safe at present. This seminar aims to provide a brilliant platform for reflecting upon some of the essential concepts of this unique subject. The purpose of this seminar is to serve as a medium that enlightens the outcome, unsolved questions, and further explore new directions in the field of space law.
With a view to ensuring organized and systematic space exploitation and exploration, it increased the need for certain international regulatory and legislative changes. Moreover, it provides a premier interdisciplinary platform for researchers, practitioners, and educators to present and discuss the most recent innovations, trends, and concerns, as well as practical challenges encountered and solutions adopted in the field of law.
Leaders instill in their people a hope for success and a belief in themselves. Positive leaders empower people to accomplish their goals. This saying is true in all senses for us. Here, we have Advocate Dr. Narayanan sir, Director, Kerala Law Academy, and Special Government Pleader for Forests, High Court of Kerala, to officially welcome our guests into this inaugural session. So please.
Respected members and distinguished dignitaries on the virtual dais and off the virtual dais, dear friends, brothers and sisters. Now, my duty is to just welcome the dignitaries for this function. There are so many eminent personalities to say who is who in the space field. So I may not take much time on giving an introduction to this subject. And you just say that Kerala Law Academy was founded in 1966. It is almost 56 years since it has been founded. It is, I may say, 56 years young. And now we are planning to go a lot forward with so many technical subjects, technology, and a lot of, maybe in the next 5 years, Law Academy, we would see a shift change where we would be competing with the best, not only in India, with among the whole over the world. So as part of this, we have so many interesting topics being discussed and having international faculty in these virtual platforms. And in the campus also, a lot of developments are taking place. Maybe in another 5 years, maybe what Law Academy was in around 50 years back, and or maybe even 10 years back, maybe different. So I'm indeed happy that we are having this seminar, this international conference, this international seminar with great personalities, distinguished personalities, who are, as I said, I repeat, the risk of repetition, I say, who is who in this area. Now let me proceed on to my duty of welcoming legal dignitaries on this function. First and foremost, I want to wish to welcome Honorable Mr. Justice A. Muhammad Mustaq sir, who is Honorable Judge of the High Court of Kerala. He is a postgraduate in law, in labor law. Subsequently, has been a well-known mediator before elevated as a judge. He was trained as a mediator by an European from United Kingdom, and also by the mediation committee of the Supreme Court of India. And presently, after becoming judge of the High Court of Kerala, and after that becoming prominent judge of the High Court of Kerala, Mustaq sir is the chairman of the computerization committee, and which is making so innovative programs and being a leader, national leader, in not only in computerization and digitalization, but also in modernizing the litigation system, especially through digital platforms. And I may say that Kerala High Court has become the first court in the whole of India to go paperless. It has already started, 5-6 courts have gone paperless. And I would say that the leadership has been given by none other than the chairman of the committee, Honorable Mr. Justice A. Mustaq sir. He is the future for not only Kerala High Court and not only Kerala, but for India, as we expect his judgments the last so many days, so many years, it has been coming out. So revolutionary judgments. I may say a judge, as Justice Cardoso says, as Justice Oliver Wendell Holmes say, a judge is assessed. He retires. What is the contribution of the judge to society? How he has transformed the society? How it has made this a living place in our planet as one of the best places on the planet. That is how we remember all the great American English judges and Indian judges, including Justice Khanna, H.R. Khanna, one of the greatest legends. I hope that long time is there for Honorable Mr. Justice Mustaq sir, and we expect a lot, and that is why I'm saying the future of Indian society, and we expect a lot from his lordship. And of course, he is a great expert in this field. If I go on narrating the various positions he holds, and go into it, he is such an expert in space law that he is faculty of learning and mediation in so many places. He's a member of the International Institute of Space Law and Indian Society of International Law. He's a managing editor of so many online legal newsletters published from Luxembourg. Then charter member and treasurer of India International ADR Association, member of Mediators Council of India, secretary of Mediators Council of India. He has so many international publications to his credit, refereed, peer-reviewed international publications to its credit, including papers presented at the International Astronautical Congress held in Hyderabad, then in Korea, Nepal, and Italy. We are extremely honored and privileged to have you, sir, here with us on behalf of all those present here and on behalf of the Kerala Law Academy and the ICLQ and all those present here. I extend to Honorable Mr. Justice A. Mustaq sir a warm welcome to this function. Welcome, sir. Welcome. Next, welcome Professor Dr. B. Reddy, who is Professor of Law and and director of the Center for Aerospace and Defense Laws, and also the director of Center for Tribal and Land Rights, which is also a very pet subject as far as I am concerned. So much dear to me, tribal and land rights of tribals. And Dr. Reddy is also serving as the course director in LLM International Trade and Business Law at Nalsar University of Law. The recent past, he has been contributing a lot to the field of air and space law, including other subjects in international law by teaching, introducing innovative and value-added courses, publishing, organizing national and international conferences, workshops at the national level, and offering advice to the government of India in matters concerning aerospace law in particular and other international laws in general. Dr. Reddy was awarded the Meritorious State Teachers Award 2017 by the Higher Education Department, Government of Telangana. He was also awarded the NALSA's Excellence in Research Award for academic year 2020-2021 for outstanding publications. On behalf of all those present here, and on behalf of the Kerala Law Academy and ICLQ and Center for Advanced Legal Studies and Research, I extend to Professor Dr. Reddy sir a very warm welcome to this function. Welcome, sir. Welcome, please.
Thank you, sir.
Next, I wish to welcome Professor Dr. Sandeep Bhatt. He is Professor of Law, Director, Center for Aviation and Space Laws, the West Bengal National University of Juridical Sciences, Kolkata. He has already been associating with us in so many functions. I have already met him in the virtual platform, and otherwise has come to our institution. So much of cooperation and so much of association this institution has with Dr. Sandeep. But I remember one earlier major space interaction degree in the campus. On that day, I remember Dr. Sandeep Bhatt was also there. He is also an eminent and distinguished personality in this field. He has major research, major by the World SRO, West Bengal Judicial Academy, Ministry of Justice, and Forest and Climate Change of Government of India. Distinction of being the member of American Society of International Law, Baltimore, and International Academy of Space Law, Moscow, Russia, and the International Institute of Space Law, Paris, France. He has presented over 125 research papers in the international and national conferences, including the coveted International Astronautical Congress, as well as in various international conferences. I, on behalf of everyone present here, the Kerala Law Academy, the Center for Advanced Legal Studies and Research, and ICLQ, extend to you, sir, Professor Dr. Sandeep Bhatt, sir, very warm welcome to this function. Welcome, sir. Welcome, please.
Thank you so much. Thank you.
Now, I wish to welcome Dr. Ranjana Kaul, who is a partner at Dua Associates, a law office at New Delhi, India, and she also specializes in international air and space law regimes. Dr. Kaul holds an LLM from Institute of Air and Space Law, McGill University, Montreal, Calcutta, Canada, a PhD in Constitutional Studies from Pune University, and an LLB from Delhi University. Dr. Kaul is Director, International Institute of Space Law, Paris, founding member of India's first independent think tank on space matters, the Space Port Sarabhai S2, launched globally in December 2021. Dr. Kaul is on faculty at the London Institute of Space Policy and Law, United Kingdom. She is a frequently invited speaker at limited audience forums, and she speaks extensively at law schools in India and internationally. On behalf of all those present here, Kerala Law Academy, and also the Center for Advanced Legal Studies and the ICLQ, I extend to you, sir, Dr. Ranjana Kaul, very warm welcome to this function. Welcome, sir. Welcome, please. Next, we have Mr. Ashok GV, advocate and partner at Factum Law. Being a technology lawyer, he has represented his clients in a variety of disputes involving tax, intellectual property, real estate, labor, and contract law in conventional and alternate dispute resolution forums. He has a very keen interest in research, publication, and teaching, and hence has published, written, published, and delivered talks in international and domestic journals and fora, including law schools, engineering colleges, judicial academies, police training centers, conferences, and seminars on subjects ranging from criminal investigations, health and pharmaceutical regulations, technology reforms in justice law, space law, and constitution. On behalf of all those present here, and on behalf of the Kerala Law Academy and the Center for Advanced Legal Studies and the ICLQ, I extend to you, Mr. Ashok GV, sir, very warm welcome to this function. Welcome, sir. Welcome, please. Now I would wish to welcome Srimati Serin Elsa John, Assistant Professor of Kerala Law Academy, will be proposing the vote of thanks. She's part of us. Welcome, Serin Elsa John. Then I wish to welcome the Director of Students and Faculty Services, Professor K. Anil Kumar, who is the guiding light for all of us, who is the lamp, who is showing the light for us, who is the man behind all these functions and so much of support for us. On behalf of all those, though he is part and parcel of us, on behalf of all those present here, I extend a formal welcome to Professor K. Anil Kumar, sir. Of course, another great man behind the show is the principal of our institution, Professor K. Harindran, sir. He requires no introduction to our students and to others also. He is so popular among the academics. On behalf of all those present here, for the sake of formality, I extend a warm welcome to Professor Harindran, sir. Then I should specially welcome Dr. Saraswati, who is yet another great personality, who has been running all around to organize this function for and is a very prolific lead in academic circles. And I should say, she is part and parcel of our institution, very important part of our faculty. On behalf of all, I extend, for the sake of formality, a warm welcome to Dr. Dakshina Saraswati, Assistant Professor of our institution. Last but not the least, I would welcome all the faculties, students, teaching and non-teaching and administrative staff who are present for this inaugural function. And most importantly, what I want to say is, most important thing I want to say is, for this conference, who are there to get all the information and knowledge. They're the most important person. I welcome them also, and I know all of you are spending your invaluable time because you are so much busy, especially Justice Mustaq sir is there in Bhopal, as we all heard, in the National Judicial Academy. And in spite of all this, he has also come here. His Lordship has come here. So on behalf of all those present here, I welcome all of you, all the dignitaries, finally, and all the participants to this function. Thank you. Thank you very much.
Thank you so much, sir, for your warm welcome. I take this opportunity to graciously welcome you two into the session, sir. Now, we have Professor. Thank you, sir. Now, we have Professor Dr. V. Balakisha Reddy, sir, Professor of Law and Registrar, Director, Center for Aerospace and Defense Law. He is also the Director, Center for Tribal and Land Right and Course, and LLM International Trade and Business Law, Nalsa University of Law. Besides being awarded with the Meritorious State Teachers Award 2017 by the Higher Education Department, Government of Telangana, he was also awarded the NALSA's Excellence in Research Award for the academic year 2020 to 2021 for the outstanding publication. A prolific writer, Dr. Reddy sir has contributed extensively to various national and international journals on different fields of international law. I take the privilege to invite Professor Dr. V. Balakisha Reddy sir for the presidential address. Sir, please.
Thank you. Good morning. And again, on behalf of Kerala Academy, I welcome you all. Uh, uh, Mustaq Sir, Professor Bhatt, Ranjana Kaul, and other organizers. It's a great opportunity to meet you all once again. So yes, I'm going to give maybe another 15 minutes. Just give an idea about how the space journey or technology law. So first part, maybe few points I'm going to highlight. Law and technology, how space technology helped in space regulations, and then what kind of initiatives we in India are taking in part of this journey. So friends, we all know that law and technology, law follows technology, or technological developments needs law. So the moment when technology happened, law has to chip in. For example, what I call is techno-driven laws, whether it's air law, space law, intellectual property, or telecom law. All these are all having a very connection, nexus between these two are very close link between these things. For example, aviation. You all know that Wright brothers invented aircraft in 1903. In the same month itself, the international community started how to regulate these flights. These are having a cross-border in nature. Can other countries be allowed? If they allowed, what kind of restrictions they can put like that? And today, over a century, what kind of regulatory mechanism we have in air law, whether it's a public air law or private air law. Similar thing in IP, and more particularly our own field, that is a space. Those space voyages, space journeys are not new for mankind. Centuries people used to dream about going into air space, but it was became a reality on 4th October 1957 when Sputnik 1 was successfully launched by former Soviet Union. And since then, lot of new developments are happening. You all know that Yuri Gagarin was the first man, and then Neil Armstrong, and today we talk about space, stations, space hotels, colonization of space, and all these developments. I can tell you, friends, we have entered a new era of solving the problems of Earth using the space technology. That is the greatest contribution, we can say that, space technology. If you talk about the benefit of space technology, I need not emphasize again and again. If a minute satellite won't work, our conference will stand still. That is the dependency we have in space technology. There is no doubt. Okay, question comes. These are all contributions by scientists. What we as a legal fraternity, lawyers, we have to do with? Yes, definitely. That's where I told law follows technology. I said 4th October 1957, that's Sputnik 1, 14th November 1957, exactly 40th day, United Nations. So international community came out with the resolution urging international community to use this space technology for the peaceful purposes or benefit of mankind, humankind, whatever. So the law began, I mean to say that. And initially in the initial years, if you ask me to put in, I know 10-15 minutes is a short time, but I'll try to give you an idea so that a lot of new participants are there. So development of this law happened in 3 phases. I call it first phase from 1957. Just now I mentioned you the important landmark event. So this 4th October thing to 1963 we call first phase, or soft law phase, through various UN General Assembly resolutions. There are 5-6 important resolutions, mostly focusing on the infrastructure and creating an organizational structure. I mean to say that COPUS was happened in 58, and it became a permanent organization in 59, and then various other resolutions using space technology for peaceful purposes. That was the phase, initial phase. We call it soft law phase, or non-binding in nature. So that's. And then second phase from 1967 to 1979, if you look at, this is what we call hard law. Hard law means, binding in nature or treaties. Here, 5 important international treaties, part of the corpus of space law. So that is Outer Space Treaty 67. Friends, this is an important, I call it charter, like United Nations Charter. It is a charter for, space activities, Outer Space Treaty 67. Then you have a rescue agreement 68, then liability convention 72, then a registration convention 75, and moon agreement 79. These 5 important treaties today, which part of the space law, space jurisprudence, and binding in nature. Okay, that's the second phase, important phase. But again, if you look at the development of space regulations, Again, we again come back to soft law. From 1980 to now, if you look at again, soft law, various UN General Assembly resolution, passed by the international community to regulate space in a different facet, whether it's a remote sensing or direct broadcasting like that. So we have UN General Assembly resolution on direct broadcasting satellites, then UN General Assembly resolution on remote sensing, UN General Assembly resolution on nuclear power sources. All these are all happened in the recent past, and more particularly one development which happened was the last UN General Assembly, so-called benefit principles. Space sector was, you all know that, dominated by few countries, though outer space is a global common. And the moment when I say global common, we all know that property has two kinds: res communis and res nullis. Space is a res communis, community property. Every country, everybody has share. But are other, all countries are taking benefit out of this thing? Those questions came in, a lot of discussions, various forums, including UN. So then, one important development which occurred, part of the international relations in general, and more particularly third world, participating the developing countries. What kind of participation can be happened, by the developing countries? Do the latecomers have anything, in the space? Because since it belongs to everybody, these kind of things to consolidate those. And more particularly, countries like India, being a leader, I can say that, big brother of space activities, more than maybe 70-80 countries are also depend on India's, they look forward the India's leadership in the space activities. So India was instrumental in bringing these so-called space benefit principles and so on. So this is a development when it comes, and of course space sector is no exception. So the global developments also impact the international space lawmaking or space sector. For example, 70s and 80s, more particularly, new developments happened in the global context, whether you got globalization, liberalization, privatization, commercialization, all these things which happened, and space, part of these global developments, also taken into consideration of these developments. And particularly if you look at now, the space sector global context also moved from scientific technological era to commercial. So that is the shift which happened in the last 3 to 4 decades. I can say that shift from earlier countries used to focus more on the technological aspects or developing the technology related infrastructure and other things. But later on 80s and 90s, a lot of commercialization happened, the commercial activities are happening, and where law is assuming a lot of importance. The question comes, though just now I mentioned, the existing so-called the jurisprudence of space law from 60s and 70s, but is it that existing, space regulations are conducive to the developments which we are talking about last, 2 to 3 decades? That was a question mark. Of course, the existing space treaties, more particularly the Outer Space Treaty 67, what we call Mother Treaty or Important Treaty, two important provisions which are a lot of discussion happened, recent past. One, Article 6 and Article 7, you all know that. Article 6 talks about the space responsibility, liability, whoever done, again it is a state. In international law, we again, states are the main subjects. So that's why state responsibility used to be placed in Article 6. And of course, is it that, correct? Today, a lot of space ventures, space activities are done by the, private companies, multinationals, whatever. So is it that, provision relevant? That is a question which last, 20, 30 years, a lot of debate is, happening, and other things are, liability related other. So these are some of the things which are happening, and more particularly, just now I mentioned the global developments. I said, particularly we have to mention these COPUS, Committee on Peaceful Uses of Outer Space, which is doing, great work in updating the space technology and space law. COPUS has two committees, one, legal committee, other one is the technology. Whatever the technology which is happening, it has to be incorporated, and COPUS successfully conducted Unispace, like 82, all, 3 Unispace conference, including the Unispace, third Unispace conference in 1999, where it, mentioned the blueprint for the space activities in the 21st century. You know, those are all. So Corpus is doing important, and it is touching a lot of new, I can say, contemporary issues, whether it is the militarization of space or then space security, intellectual property protection in outer space. Then we have a space tourism. We talk about space tourism, then space mining. These are some of the challenges which the contemporary space law posing, and more particularly keeping in view of the majority of the developing countries. We, as I know, part of the developing countries. So these are some of the challenges. Space tourism we talk about, and space tourism is a happening thing. But do we have adequate legal provisions to regulate whether space tourist is part of astronauts? Like, astronauts are the envoys of mankind. But what is the status of space tourists? It is a commercial activity. So there are certain existing, and I don't say lacunas or loopholes in the existing space law system, where I think some discussion, some filling the gaps of these things is need to be happened. So this is generally when you look at the global scenario, international space activities. Of course, I said India being a leader in the space activities, there is no doubt. India is one of the spacefaring nation, and more particularly part of the developing countries. So we also doing extremely well in the technology front. We all know that. My colleagues know very well. The team which we can see here, whether it's Ranjana ma'am or Sandeep or sir, we are all last 3 decades. I can say that when I was a student in JNU in 90s, so I started in 1996 first article. Okay, now up to India is doing extremely well in the technology, but legal front we don't have a space law. So it is a time for countries like India, so had to come out with space law. So a lot of writings by the we all part of the space students or space activists. So we started in the last 30 years, and of course in 1996, you can recollect my book on recent trends in space law and policy, where I wrote, up to now there is no space law, but it is now time for India. We need space law because India is doing a lot of commercial activities. So these are all, and in tune with those things. Of course, I have a lot of discussions, and of course government has constituted committee, part of that, many of us part of that, and space activities bill on the domestic front. We have again revision of the space activities bill. All these developments which are happening, and recently government of India also again instituted created new institutions to help to strengthen the private sector participation. Part of, whether you call it recent initiatives, including the in-space, New Space India, and also we have Atmanirbhar Bharat. Lot of push was given, in 2020, part of the COVID. That I call it COVIDization. COVIDization has, like globalization, liberalization. COVIDization is going to impact the global society, and it's going to happen. And the COVID context particularly, I think, almost all sectors, all segments, all countries in the world have impacted by the COVID pandemic 19, and the space sector is no exception. That's why I call it the COVIDization. Of course, last semester I offered a course on COVIDization, its impact on international relations. What kind of impact? So friends, we all know that so earlier we used to talk about globalization. We know what kind of impact globalization, whether positive, negative, all the. I'm telling you, as a student of, again, international law, COVIDization is going to have a similar impact. Earlier, we used to talk about international relations based on, BC, before Christ, after Christ. I'm telling you today, international relations hereafter, we are going to talk more like pre-COVID, post-COVID. That is the kind of impact we have seen, COVIDization. And of course, how the space sector actually impacted with this COVID pandemic, whether it's a launching to everything. And in India, we have also seen postponement of very many, launches. So these are all some of the things we had to keep in mind. I know very excellent sessions you are going to have for, various 6 sessions covering different dimensions of space law. So I think some of these things you are going to touch, and again, I thank you for giving me this opportunity, and I wish you all the best for the remaining sessions, and thank you very much.
Thank you, sir, for filling us with the awe and joy of your wisdom. Now we have the esteemed presence of Honorable Mr. Justice A. Muhammad Mustaq, sir, Judge, Kerala High Court, Chairman of Computerization Committee, the Chairman of the High Court Legal Service Committee, and an expert in space and law telecommunications. He has many international publications to his credit, including papers presented at International Astronautical Congress held in Hyderabad, Daejeon in Korea, and Naples in Italy. Having been a part of the Standing Council for Kannur University, he has appeared representing educational institutions, telecom companies, local authorities, and many others. He has also practiced in civil, criminal, constitutional, commercial, administrative service, telecommunication, IP, and IT laws. He has made a mark as a faculty for training on mediation with IIAM, a panel arbitrator of ICADR and IIAM, and member of International Institute of Space Law and Indian Society of International Law. I am deeply privileged to invite Honorable Mr. Justice A. Muhammad Mustaq, sir, for the inaugural address. Sir, please.
Thank you. Well, good morning to all audience on the online, the virtual platform. It's good to see my good old friends, Ranjana, Alex Shetty, and Sandeep. I think this would signify that space law has not grown much, because old faces are still remain in everywhere. Except I see that Ashok, Venkatesh Murthy, all other old faces. Well, ever since COVID inflicted upon us, I see drastic changes in our approach in holding webinars, lecture sessions, etc. And I must say, the Nagaras never failed in exploring these new opportunities. And they've been, I think it's the 14th session, it seems, like we have mentioned in this speech, welcome speech. So whenever I get the WhatsApp message of hosting such webinar, I want to be able to gather all the experts across the globe in one platform. And they may really capitalize this opportunity. As Balakrishna pointed out, the COVIDization is really happening in law academy. And that's what really meant for the students, that COVIDization. Well, I shall begin where Balakrishna Reddy left. He said, law follows the technology. I mean, that concept is the old concept where the mercantile law, the merchants, and the law followed the merchants. This is how the mercantile law followed. I think this is something we need to redraft today. Technology should follow the law, not the law follow the technology. That's where the real concerns. I think that's where we need to look at the law. We have been looking at the law as a medium for regulating the behavior or relationship. Of course, law is, as it is, a regulatory tool to balance different interests and relationship. But law has a different character and facets, the transformative role. And that's where we, especially academics and law students, has to focus. That transformative role is not happening. If you look at many of the developments happened in space laws, technologies, space technologies, or any other technologies, you find it cannot take off for the reason that want of law. Who makes a law? Our parliament and statesmen. They have no idea what is happening in the ground. They have no idea about how the technology can have impact, or even any other, even AA or whatever. So who has to take the lead? The academics and the law students. Legal professionals, especially lawyers, are only often can be termed as a beneficiaries or they would take whatever there in the realm. But real changes are the academics and the law students who wants to enter into profession. And it's onus on you to bring changes. If you look at certain examples, and we find we badly need the laws in a transformative character to change and bring changes. If you look at the history of the Galileo, the European constellation, it could not take off for the long years. They failed in a sense in bringing a kind of regime. You look at the other system constellation, Gagan. They start speaking about Gagan for more than 1 or 2 decades. It's not happening. It's not because we don't have technology, but we don't have a mechanism to transform those commercial potential of the technology into reality. That transformation only can happen through the medium of law. This is where we need to put a lot of our efforts. If you look at the history of the, as mentioned by Balakshmi Reddy, the history of space law, starting from the Outer Space Treaty in 1967, all in regulatory nature. In the era of Cold War, youngsters might not be knowing this, what is a Cold War. It's a kind of war between USSR and then USSR. Now there is no USSR. May not be know what has happened and disintegrated the USSR. Now we call Russia, different countries, Ukraine, etc. Then Cold War, in the era of Cold War between the US and the USSR, the launch of Sputnik in the outer space raised many eyebrows, and people feared the war would escalate to the space, outer space. That was a fear. When outer space treaty was made, it is to allay that fear. They made the regulatory behaviors of all the countries to use outer space for common humanity as a benefit of the common mankind, the risk communist principle. So outer space, it's part of the common heritage of mankind. So it can only use the betterment of mankind and de-escalate all sort of military activities in outer space. That was the intention. It was more in the regulatory nature. So you look at any other convention, Liability Convention, Moon Treaty, or assisting astronauts or something like all sort of conventions, treaties are in a regulatory nature, were to regulate the behaviors of nationals and internationals and who are engaged in space activities. It has no character of transformative utilization of space, outer space. The commercialization of space came in, it started from post 1970s and 80s, and especially in the era of artificial intelligence. There is immense potential for utilizing the outer space for commercial advancement. Of course, ultimately, commercial advancement is to benefit mankind. Now, there are 3 aspects involved in every venture, every enterprise, in every organization. One is the project and technology. Second is finance, is the financial aspect of it. The third aspect of it is law that bring everything in order. Now, most of the space activities are undertaken by the state. The state has a limited role in advancing and making it in the commercial venture. But state also needs finance for a project. That's what the story of the Galileo. If you look at deeper into the story of the Galileo, the European constellation of 24 satellites, it has a lot of issues relating to project financing. They have a good idea. The PPT model, they initially thought of some private interest will take, bear the brunt of the cost, but it didn't happen, it used. We have an issue Antariksh, there was, that spectrum, you might have heard about spectrum allocation issues. The ISRO, his commercial wings is Antariksh. I think it's, I'm sorry if I spelled wrongly, Antariksh, I believe. They entered into some kind of contract and it went into trouble. Why such kind of trouble? Because we don't have a law in place. Our statesmen have no idea. It's a kind of contract when some public sector organization enter into it, it may run into trouble, sail into rough weather. The problem essentially is, if you look at the space activities are related to the law. It is only through the law we can take the benefit and advantage of technology into reality or commercial exploitation. And no other medium is available. So that's what I said, we need to change. And the phrase that the law follows the technology or law follows the merchant, we have to say the technology has to follow the law. First, you have to bring the law first. Then use this technology and bring into the action. So we have to look into the transformative character of the law to bring changes and effective exploitation of this technological advancement. The same thing going to happen when artificial intelligence is our pervasive control of every affairs of a human. Even speech subject will ultimately, I will have a kind of algorithm in the network which will be used. Who can control these machines? We have made all laws to bring kind of regulatory relations between nations. That's what called the public international law, states. We all made kind of laws to control human behaviors and within human relationship. But we don't have a law related to the activities of machines and the human, because machine is going to control on every affairs and every aspect of our life. What kind of law we should have regulating our behavior with artificial machines? You have to think about it. When it penetrates, machine penetrates every aspect of our life. It can have an impact on social, political, economic affairs of human. So how are we going to regulate that? As I said earlier, the statesmen have no idea. It is for the academic and law students have to take up the task. Now, one way of looking at, perhaps you can advance yourself, because I believe predominantly this is a crowd of law students. I think it's one way of you can think about making all of the research is looking in terms of private international law. The public international law is, of course, it's something which we can't demand, but certainly the research can focus on private international law. When you are looking in terms of satellite navigations, my papers are on interoperability of satellite navigations and kind of issues related to it when using it for air traffic management. There are areas for you. Just look at the fundamentals of private international law, then look at the technology, then try to correlate both. This is where the research should happen. It can be a real game changer, the private international. We have some agencies like Untitled based in Rome and Hague conferences in Hague. They're working on certain papers. In fact, the space assets, the Untitled have made certain work on as for using space assets, because it do a lot of things. You know that ultimately the public, the financial institution will have to fund for the project. How to secure the space assets? What are the legal regime they require? These are the areas where we have to look at. We are not looking at the technology. We do not look at the technology itself. But to hate the technology and benefit as a human, we need the law. The space tourism, the Malak has referred it. it has a lot of issues. How to regulate space tourism, and what would be the consequence if something has happened? We have air law, but that will not. Ranchana is very specialist in air law. It has no application beyond certain space. Now, what kind of law that would apply if something happens in outer space? What kind of a law when apply when different navigations which operates in integrations like a GPS of the US, suppose in the Indian Gagan or the Galileo of European constellation or Glassnose of Russia, if they all operate in one stream, what would happen if some mishap occurs if it is used for air traffic management? What kind of law that would be followed? So there are potential areas for you to work on. And if we are using many of the satellite images, lawyers in Kerala particularly know that, and we have a lot of issues relating to a law called paddy lands. Paddy, an enactment came into 2008, where government prohibited conversion of paddy land. So now the courts are relying on satellite images of 2008 to whether the land was remained as a paddy or not. We are using it and the purpose of evidence in the court. We have issues of space debris. It causes a lot of pollutions. We use space for all purposes, but we are not looking at the issues related to the debris. It causes environment pollution. So how to control and those issues, how to regulate those issues. Now, this is where I think your academic bent of mind should focus. And that should really start from the academic institution, and everyone else have a limited role in streamlining it. People like us guide you, the youngsters. And the moment you step out from the law college, you just enter into a corporate law firm or a litigation firm. I think you should start something when you're inside the college with the help of the professors and lecturers. You start thinking about it. Then, of course, with that idea, you can step out. Otherwise, you become stereotype lawyers like any other, and you will not be able to take forward the what your vision from the law college. I think the time has come for the students to think about using private international law as a platform for transforming the advancement made in space or technology, whichever platform, artificial intelligence. I'm sure that the platform like this would be an eye-opener for everyone. And I'm sure that this will benefit all the students as well. Formally inaugurate this program. Thanking you one and all for listening to me, and also Nagraj and Law Academy for inviting me. Thank you, Shehi, and have a good day.
Thank you so much.
I also said, yeah, I may leave around 10:45 because I have a program at NJ at 11 o'clock. I wish to hear everyone, Ranjana and Ashok, but thank you.
Thank you so much, sir, providing us the opportunity to imbibe your words of wisdom and enlightening us with the very same. Next, we have the presence of Professor Dr. Sandeep B, sir, Professor of Law, Director, Center for Aviation and Space Laws, the West Bengal National University of Judicial Sciences. Sir has experience of researching on 5 major research projects sponsored by World Bank, ISRO, the West Bengal Judicial Academy, Ministry of Justice, and Ministry of Environment, Forests and Climate Change. Dr. Bhatt, sir, has published 4 books in space law and 3 books in medical law. In addition, he has published more than 50 articles in journals of international and national repute. He has presented over 125 research papers in international and national conferences, including the coveted International Astronomical Congress, as well as the international conferences held in Jakarta, Seoul, Sharjah, Singapore, Paris, and Cambridge. Sir also has the rare distinction of being a member of Indian Space Research Organization's Expert Advisory Group for drafting the National Space Act for India. I'm extremely delighted to invite Professor Dr. Sandeep Babadwai, sir, for the keynote address. So please.
Thank you so much. Is my screen visible?
Yes, sir. It is.
All right, so you can see my slides, right?
Sure, sir. We can see.
All right. So very good morning to all of you. Let me first actually congratulate the Kerala Law Academy for not just actually having the conference on such a very significant area of the law, but also getting actually people across the globe, right? So, I mean, I can see many of my close friends, overseas friends, who are also being part of this particular conference. We have Professor Ricky Lee. I can see actually Yun Zhao also being a part of a session. I think Elga Sadeh has already presented in the early morning session. So I can see many of them being part of this. Apart from that, even in this session, some of the best space law experts, right? So I can see Professor Reddy, Justice Mustaq, Ranjana, all of us, actually, I mean, all of us who have actually met many times earlier as well are also the part of this particular session. So it gives me immense pleasure to be part of this and also to provide the keynote address. Now, I think the previous two presentations, one by Professor Reddy and subsequently by Justice Mustaq. First of all, Professor Reddy spoke about the practical issues, especially the law follows the technology. That's the reason why there is a kind of a concern. That's what he basically pointed out. And then Justice Mustaq basically said that, no, it should be the reverse. We should basically have the law in place for the purpose of properly regulating the technology. I think this has given a kind of a perfect platform for my address, because I'm going to focus on a particular specific issue. That's the growing unilateralism in the space commercialization. I'm primarily saying about how the development of law is going on at present, right? Even though we are trying to actually develop the law, how that unilateralism has become a big concern in the present day context. Let me also clarify that this presentation should not be misconstrued as something against the space commercialization. I'm not saying that there should not be any commercialization of space. Of course, it is a necessity now. We may have to look forward for the purpose of supporting the growing population. Commercialization may be an inevitable aspect. But my focus is more in terms of the fact that the unilateralism should not be the mantra in terms of developing the law with respect to space commercialization. We should be having the multilateralism rather than unilateralism. That's the crux of my actually this keynote address. Now to start with, Professor Reddy gave the details. I should be really thankful to him with respect to whatever he spoke of. It has been made the things easier for me. As all of you know, the international space law has got actually very strong root in the common rights regime. The developments in the 20th century, especially the 5 major space treaties, if you look into them, they advocate for the common rights regime which is applicable to outer space. It is res communis or a kind of a variant of a res communis, which we find in the outer space activities. This is primarily because of the fact that outer space and celestial bodies and even their resources are considered to be the charity of nature. They are the bounties of nature. When we agree they are the bounties of nature, it means everyone in the world need to have rights in it. That's an equal or at least an equitable right for everyone with respect to these bounties of nature. And this is the very reason why the outer space law has developed on the strong edifice of common rights regime as against the individual rights. Whenever somebody is actually using these common resources, there is a requirement of respecting others' right. Maybe at least the activities need to be carried on for the benefit of everyone. and any benefit which has been derived out of the space activities need to be shared amongst everyone. All these things becomes essential in a common right regime which is applicable to the outer space. And we can find this strongly rooted in the so-called Magna Carta of space law, the Outer Space Treaty. We have Article 1 speaking about province of all mankind. Outer space, exploration and use of the outer space shall be the province of all mankind, which is a variant of a res communis regime, not a res nullius. It's not a monopoly right, rather actually the right of everyone in these resources, use and exploitation or exploration is the essence of province of all mankind principle. Article 2 of the Outer Space Treaty speaks about a prohibition on national appropriation. And it says there should not be national appropriation by claim of sovereignty, by use or occupation, or by any other means. There is a clear-cut prohibition. But unfortunately, many people have started to misinterpret this provision by saying that the national non-appropriation means only a prohibition on the state appropriation, but not on the private players. Private players can appropriate the outer space and celestial bodies because Article 2 does not explicitly prohibit it, which is an absurd interpretation, especially when you look from the point of view of the drafting history of Outer Space Treaty, as well as if we have the common understanding of the property rights regime, both in the common law countries and the civil law countries. National should not be interpreted as the state. It's not confined only to the state. It is also extends to any individual who is carrying on activity in any of the states. And I can also actually supplement this in the Outer Space Treaty itself. If you look into Article 6 of the Outer Space Treaty, it clearly says that a state is responsible for all national activities, whether carried on by the governmental or non-governmental entities. It also uses the term national activities. And it is very clear whether it is carried on by the governmental entities or by the private entities, both of them are covered within the ambit of Article 6. So national should not be interpreted as only the state activities. It also extends to the private activities. Added to this, if we come back to Article 1 of the Outer Space Treaty, it also categorically speaks about the freedom of exploration, use, and scientific investigation. Every state has got a freedom of exploration, use, and scientific investigation in outer space and celestial bodies. Everyone has got a free access to these regions. So once we accept the freedom as a regime applicable in outer space, we can't simply advocate for an individual right or a monopoly right in the outer space and celestial bodies. So it is clear that the space treaties, which are binding on all the parties, including actually majority of the spacefaring nations as well, because Outer Space Treaty has been signed and ratified by almost all these spacefaring nations. Whether it is US, Russia, India, Japan, all of us are the parties to the Outer Space Treaty. So this common rights regime is something binding on every one of us. Now, Professor Reddy also pointed out about the shift from the public sector space activities to the private sector space activities. Right? So though it is from last 3 decades or so, you can find that in the 21st century, we are in the era of private space activities. More and more investments by the private sector we have seen. Much of commercialization, different kind of commercial activities have boomed like anything in the 21st century. As I told, commercialization is not a big problem. Problem is the unregulated commercialization. And attempting to go for laws or the policies which is based on unilateral interest rather than multilateral spirit. 20th century developments have all happened on the basis of multilateral spirit. States came together, they negotiated for the treaties, they brought in the principles applicable to the space activities. Now we find the unilateralism, especially by the major spacefaring nations, I should say led by the United States itself. Look into the number of licenses which the United States is giving to the private players. SpaceX alone has got nearly 2,000 satellites in space now. One single private company having 2,000 satellites in outer space. And if you do a little more research, they have already got licenses for 42,000 satellites. SpaceX has got actually the licenses for 42,000 satellites to be launched into the space. There is a litigation in the United States. It has been very recently filed. Last couple of months, actually, it has been filed in the US courts for the purpose of having a moratorium until the time a proper regulatory regime is brought in the United States. Because the current policy of the United States is to promote as much commercialization as possible. Competition rather than regulation would serve the best interest of US. You have to have more and more competition. That's the mantra of the United States. So in this zeal, they have gone for indiscriminate licensing, and their laws are one of the weakest laws in terms of actually preventing maybe unsustained use of outer space. They're giving licenses freely, almost freely. So the consequence is that they are taking up the space of other international community members. Other states might not be able to find place once their private space activities start. So outer space would be filled with these US entities or maybe spacefaring nations' satellites, and maybe the developing countries or their enterprises might not get sufficient actually space for the purpose of having the satellites and space activities. So this is really a problematic unilateralism which the United States is going forward with. Space tourism. Again, Justice Mustaq has spoken about it. You know, the private space tourism started last year, 2021, with the launches. You must also be knowing that within a span of just more than 1 year, we have got many private tourists who have already gone to the outer space. And few thousands have already signed up for going to the outer space in the very near future. What is the regulatory mechanism for space tourism? Except an informed consent. If you look into the US law says that from the tourist, you have to take an informed consent, and then you can launch the tourist to anywhere. Right? Just an informed consent, nothing else. No other proper regulation has been brought in with respect to the space tourism. Similarly, plans are also going for celestial habitation. The pioneer agency like NASA has already got the plans, but at the same point of time, even the private players are also planning for celestial habitation. We can't say that actually there would not be any colonization. There would definitely be colonies of the developed countries in the celestial bodies in the near future. So such a kind of a unilateralism is really a greater concern, and might be that the colonization is on card by virtue of it. And more importantly, the basic theme of this particular conference, the property rights, you can also find the developments which have taken place unilaterally regarding the resource exploitation. I don't know how many of you know about it. 2015, United States passed the Asteroid Act, an act for the purpose of permitting mining the asteroids. Not just mining, but even the private players can have property rights over these resources. Individual rights, without any question of benefit sharing, without considering the interests of international community. What is the argument? US argues asteroids are not celestial bodies. Celestial bodies are only the bigger bodies, which have got some astronomical significance, etc. Asteroids and meteoroids don't come within the ambit of celestial bodies. From where did this interpretation come in? When the space treaties were entered, there was no such kind of a distinction which was maintained between the bigger bodies and the smaller bodies. Asteroids were also considered to be celestial bodies. Now they say that they are no more the celestial bodies, therefore we can exploit. We have the free rider. We can actually, our private enterprises can exploit these resources. 2017, Luxembourg has also passed the similar law on mining. Other countries are also following the footsteps. The Middle East countries, they're also developing the law for the resource exploitation from the celestial bodies. 2020, United States has also come up with Artemis Accords. which is actually an accord for the purpose of mining the resources from the moon. They have come up with the structure, some actually the principles, and they have also sought the international cooperation with respect to mining the moon resources. Some states have also become parties to this Artemis Accord. Maybe India is also considering, but I should say that this is also not acceptable. On the one hand, unilateral move in terms of permitting property rights or celestial resources rights by the national legislation. On the other hand, even the Artemis Accord, I should say, is a kind of a unilateral movement, because it is not by virtue of actually calling different countries and negotiating a treaty and having the spirit of multilateralism. It is nothing but United States superimposing certain thing and asking other countries to come forward and cooperate. That's it. I don't think that actually it's rooted in the spirit of multilateralism. Rather, this is again a depiction of unilateralism in the international level by the United States. So we are having the problems in terms of resource exploitation, which would again lead us to the colonization problems. Finally, this might also be a problem which is going to be escalating in the future. There are already people who have claimed the property rights over the celestial bodies. And some of you might be knowing that they are selling the parts of the different celestial bodies. If you haven't heard of this, please go through www.lunarenmbassy.com. A person by name Dennis Hope from the United States is selling the parts of the moon and other celestial bodies. He has already sold many portions to different people. Problem is, United States, being a responsible country under Article 6 of the Outer Space Treaty, has not taken any action against this fellow. Or maybe the other people who are also trying to claim any property rights over the celestial bodies. What does this mean? If you look from the international obligations level, it is a failure to comply with the international obligation. Article 6 speaks about responsibility of every state with respect to not only governmental activities, but also non-governmental activities. So these kind of activities need to be condemned, and there is a requirement of ensuring that we will not go by the international regime, which is based on unilateralism. Rather, it is based on the spirit of multilateralism, as we have evidenced in the 20th century. If not, if we are actually bypassing this multilateral spirit, we might be having the outer space and the use of outer space for the destruction of mankind rather than for the benefit of the mankind. So this is the time to actually wake up and ensure that the proper multilateral regimes are brought in for the purpose of regulating the commercialization. That's all. Thank you so much. And I wish you all success with respect to the remaining sessions of this conference. Thank you.
Thank you so much, sir, for your valuable words of wisdom. Now, we have Dr. Ranjana Kaul, ma'am, Partner at Dua Associate, Law Office, New Delhi. She's the Director of International Institute of Space Law, Paris. She holds an LLM from Institute of Air and Space Law, McGill University, Montreal, Canada. PhD in Constitutional Studies from Pune University and LLB from Delhi University. Dr. Kaul advises stakeholders, including commercial companies, on regulatory intersection between international space treaties and national space policy, including for commercial space activity. She's a frequent invited speaker at limited audience forums, and she speaks extensively at law school in India and internationally. I'm deeply privileged to invite Dr. Ranjana Kaul, ma'am, for the special address. Ma'am, please.
Thank you very much. And of course, my colleagues who have spoken earlier have touched upon very many salient points. Professor Reddy and Sandeep Bhatt have given a great exposition. And Justice Mushtaq has provided what a lawyer would do, which is to provide an applications-based approach to whatever it is that are the gaps that we need to fill up. So being a comrade in the profession, so to speak, and we have, of course, Ashok here as well, so we're the three of us, I believe that it is time for me to give you my perspective on what I believe is actually the format here. So here's the thing. Outer space has always been and shall always remain primarily a military domain. It is true that India is a country, perhaps the only one, which ab initio conceived and has been delivering a civil space program, chiefly because our leaders of the time did not want to do a military space program. Every other country has had a genesis in the military approach. So first and foremost, it is a military domain. The Sputnik, as you will well know, was a military communication satellite. A few weeks later, in December, the United States launched the first international ballistic missile. But in the intervening months or weeks, as Professor Reddy pointed out, there was already a UN General Assembly resolution on peaceful uses. Now, the question that arises is that at that relevant point in time, what was the objective of these two superpowers that are in eyeball-to-eyeball confrontation through the First and the Second World Wars and ongoing, because they are on opposite sides of the ideological divide? They do not want either to get ascendancy in space, that is to control space. They want each to have the liberty and the possibility of going and testing weapon systems. They want to be able to explore and use the natural resources. They are well conversant with what is spectrum, because without that you cannot do anything. And it is that, it was certainly not an altruistic motive. Why is it that these countries decided to take their proposition, which could very well have led to another war, which they didn't want to, they didn't do it, they took it to the newly established United Nations Forum. And as Professor Reddy has pointed out, started with establishing the COPUS. Its secretary is the OSA. And they spent 10 years going chapter and verse, comma by comma, word by word, phrase by phrase, and delivered the Outer Space Treaty. So what is that Outer Space Treaty precisely doing? Surely it deals with the space object, but what is a space object? It's an inanimate box, really, that is up there, and there is this tube called the launch vehicle that takes it up. And as Professor Reddy was saying, and everyone else has said, it's all about technology. So it is the technology embedded in that box, the object, whether the vehicle or the satellite. Now, what are you going to do with this box and technology without the bloodstream, which is spectrum? The point of the matter is that the Outer Space Treaty wants to control and does control the manner in which the technology in that space object will be used in conducting activities in outer space. The fact that they went to the United Nations, which is now at the relevant point in time, don't think about that the fact that UN has 193 member states, all sovereign countries. But at that relevant point in time, how many were there? Most of them, like us, and many others like us, had been colonial power. They had recently become independent. Some others, like Brazil, had already been independent over 100 years before. But by no stretch of imagination could they have been described as advanced technologically, economically, scientifically, or in any other way. We were all clubbed together as developing countries, not even developing actually. We were the North and the South. Back in the day, the phrase was North and South. But for the first time, here are these countries which have one vote, and each vote in the United Nations is of equal caliber, so to speak, put it simply. Equal vote are being asked to offer their opinion on a subject. And without them having had ever thought about space activities, benefit, this, that, and the other, whatever, they're saying, no, the common interest has to be, Brazil has played a great role in getting that common interest principle. And remember that treaty is a bunch of principles to guide the activities, human activities in outer space. How did it transform? As Sandeepa Bhatt and Bala Reddy have been saying, as Justice Mushtaq has been saying, how did it become this great big concept of global commons, which of course Sandeep knows very well, has been roundly rejected by the Americans several decades ago. Be that as it may, the fact of the matter is that it democratized space. It is only after the fall of the USSR that the United States, finding itself as the only superpower in the world, actually permitted all of these military technologies to be utilized for commercial purpose. Until then, only the advanced countries had the benefit of that. None of us did. Fortuitously for us in India, it coincided with the time when Prime Minister Narasimha Rao and his Finance Minister, Dr. Manmohan Singh, actually delivered a liberalized mechanism for partial deregulation of the Indian economy. And suddenly, many of us will remember here, you had a Google in your life, you had a mobile phone in your life, you had all kinds of wonderful gadgets. It took a while getting used to it, but we are now entirely dependent. Your generation has been born with that technology available. You take it for granted. But it may not be, as Sandeep has been pointing out. Now, the question that arises is, at that relevant point in time, if you were to look into the legislative history, what will you find? That all of these countries, we may all have been in rags at the relevant time, but we were sovereign countries. And we all played a role in getting what is known as the common principles, due regard, so forth. Now you tell me, where you have a situation which says peaceful use, what does it mean precisely? Peaceful use for two belligerent powers. And the greatness of these two belligerent powers is that they didn't, as if, make best friends with each other thereafter. They remained adversaries. But they found a modus vivendi. And thereby, by continually, consistently undertaking space activities as provided by them in their own law, which is international law, outer space, they established state practice, the manner in which a country conducts itself. As on date, there is not a single country that you can say has acted contrary to the state practice as envisaged or as has been the outcome of the principles of the Outer Space Treaty. Yes, there are national laws. Every nation has its national objectives, and there is an eternal conflict between international obligations and national objectives. You can't fault that. Doesn't India have national objectives? Of course it does. It is a sovereign state. It will always, it's all about geopolitics. Everything that happens in outer space starts and ends here on the Earth. So the question is that today you have a situation, as has been pointed out, of the superpowers in space. There are 11 space-faring powers. Starting with 2, you now have 11. Out of those 3 are the super space powers. That is to say, USA, China, and Russia. But of those 2, there are the 2 uber space powers. So in the 21st century also, there is a confrontation between 2 mega powers, and the third one is aligned with one of those 2. That is the situation in which we are now. The next thing you need to understand is that international treaties are applicable as between the state parties that ratify them. There are today 112 states that have ratified the Outer Space Treaty and very much fewer all the other treaties, and only 18 for the Moon Agreement. It clearly the most unpopular of all agreements, international agreements. But the Outer Space Treaty is the one that has the bulk of the ratification. There are 193 altogether countries that are member states. There are 23 more that have signed but haven't completed the ratification process, and 58 have neither signed nor ratified. That is the status of the Outer Space Treaty. Now the question that arises here is obviously a problem where after 1991, when globally these military technologies were enlarged for commercialization, look at the humongous number of the global space economy, what it was estimated to be in December 21. And here we are only talking about the space to Earth economy, only within the orbit of the Earth down to the surface of the Earth. Inevitably, as that gets saturated, humans, look, our destinies as humankind is linked intrinsically with the moon. When Buzz Aldrin and Neil Armstrong landed, that's what happened. It is inevitable that humankind will want to go and explore beyond the moon. We have all the countries have been, at least the 11 countries that are spacefaring powers are undertaking deep space missions right to the edge of the solar system. Is it not going to be time to commercialize? Yes, but how are you going to do it? That is the moot point that Sandeepa was talking about. I mean, is it going to be my way or the highway? How are you planning to do this? Now, the question that arises is that as far as the Artemis Accord is concerned, the opening paragraph says that it is a political agreement. It is a political agreement. The Artemis Accord is a political agreement between the United States, that is to say NASA, the space agency, and whichever country it is that is signing up to it. And all of this is to support the Artemis project, which has been criticized by the other super space powers to say that, it is entirely American-centric. It has nothing to do with, so that is where it is. The opposite side says, no, we believe in a rule-based outer space, and we believe that, it should be, multilateral through the United Nations institutional mechanism. So, of course, these games will be played. But that doesn't mean it's overtaking our lives if we don't want it to. It's our option. A country wants to sign up, well, so be it. There is one which has signed Artemis Accord and thereafter gone and ratified the Moon Agreement. So my question to you is this. Look at the development of space today. As a lawyer, a practicing lawyer, I'll tell you this, that only academic knowledge, you must have a thorough academic knowledge. You need to study customary international law. You need to study what is state practice, what is a binding rule of customary law. Outer Space Treaty doesn't have definitions, it doesn't have monitoring, and it doesn't have verification. How then are countries conducting themselves like this, such that there is accumulated state practice that has allowed today 80 countries are accessing space. 11 are spacefaring. The economies, the safety, the security architecture, everything depends on space-enabled services. And surely life is unequal. After all, when you look at the General Assembly resolution on remote sensing, what is it saying? That the data that is acquired by a satellite, there's no sovereignty, so you can't prevent satellites from going overhead. That data, that is to say raw data, will be provided to the country that is being sent at the same rate as it would otherwise to anybody else. So what should a poor country do with that raw data? Do I even have the technological capacity to actually make it machine readable? Most likely not. So what do? I say, Professor Bhatt, I understand you are getting on with this wonderful satellite imagery service. May I buy it from you too? May I subscribe to it? And he said, yeah, sure. Here's the form. That's how it works. That's real life. So the question here is, what is the role of the other members of the UN? There are 193. If you have 1, 2, or 3 who you feel that seem to want to sort of dominate the conversation and the narrative, what is the role under the UN mechanism that all of our countries can play? Do we have a role? Do we think we have a role? Have we undertaken an analysis of exactly what it is that and how our economies would be impacted if there is some deliberate catastrophic event in outer space, or even an event that is not intentional, where you have a situation where there is information about the humongous size of these low Earth orbit constellations, 40,000, another one has got 3,000, our own OneWeb with an Indian partner in the UK has got 750, I believe. And there was, a few months ago, actually a application that was filed in the ITU for, it coordinates frequency so that there's no harmful disturbance when in the same band frequencies are being used, of 3 lakh, a constellation with 3 lakh small satellites. I mean, it did the rounds, within our own IISL sort of network. And for a minute, you could not grasp this whole number. Of course, it was rejected on technical grounds, but is there a possibility? And remember this, of the 193 countries that are UN members, every one of them is a member of the ITU. There is no dispute amongst them. Why? because nobody can operate without spectrum. You so don't want to rattle that boat. There was a discussion about airspace, international air law, which Bala Reddy was talking about, and I think Justice Mushtaq referred to it as well. Well, how many members does the ICAO have, International Civil Aviation Organization? It's part of the UN system, all 193. Why? Because it's humongously lucrative. Civil aviation is a humongously lucrative proposition. You so don't want to rattle that boat. But outer space, it is young. You want to go down to the moon. Question that arises is there anything that stops the superpowers, all countries, to go to the UN, just like they did back in the day, established a COPUS, established a USA, and got on with the job, go back to the UN and say, well, we need to have an international mechanism to regulate planetary resource mining and the colonization of the celestial bodies. There's nothing that prevents. So what is the problem? And therefore, I urge you that when you are studying, please look at the context of how it happens. You must learn to apply the law in the facts and circumstances of every case. Don't pick up a word from here to there and say, no. So, harmful interference. Now, ITU says that, and so we should include, for example, you're talking of national law, space activities law for India. What is the meaning of that? It is the manner, the harmonization of India's international obligations into domestic law, which must necessarily be legislated by Parliament. So what are you going to say? I don't want India at all to, I support this whole business of controlling debris and all this extraterrestrial material and so forth. And in my draft proposal for what should be the liability clause, I'm going to add environment. Now, let me tell you something. When you're talking of extraterrestrial and environment, every single thing, starting from Sputnik and the many hundreds and thousands of nuclear and thermonuclear tests that have been, the vehicles that took them up, before that, before the partial test ban treaty was ratified by these states, is man-made, it is extraterrestrial, and it is a direct assault on the pristine environment of outer space. So if you have a proposition like that in your national law, and first and foremost, who's going to bother about your national law? Only you. And if that is the case, and it is passed by Parliament and notified, I will ask my colleague here, Ashok, let us file a writ petition, and we hope that Justice Mushtaq will be hearing that, to say that India should halt her space activities forthwith, because everything sent up in space is an assault and a potential cause for causing pollution in outer space. Does that work for us? When you are drafting a law, you have to ask yourself, why is it that the international treaty, Article 7, does not include environment, damage to environment? There must be a reason. And then you ask yourself, what does it mean precisely? Peaceful use, what does it mean? You have to go back to the legislative history of the way in which the discussions that happened in the UN pertaining to the meaning and the negotiated understanding and interpretation. Remember that only two parties dealing with this at the time. It means non-aggressive, because if they had said non-military, then everything would have halted, including whatever they were doing, including their assets that were then in space, isn't it? So you need to go into the root of the matter. It's only when you understand that you will apply. And it's only when you apply that Justice Mushtaq is saying that it's you, the student body, who must take the trouble to develop a forward way of dealing with this international law. It is not an easy task to do. It needs a lot of hard work. It needs a lot of being alert to what is happening around you. Now you take a case, for example, of Ukraine. You have the Starlinks that were providing satellite services, strategic services to the Ukrainian defense services. Was it a violation of Article 6? Of course not. For the reason that the authorization was provided by the US regulator. So there was no problem there. Nor is there anything in the Outer Space Treaty, or nor is there a treaty indeed, that tells you about how satellite-based services are to be viewed in context to a force multiplier support for armed services. So where are you coming with this that they should not have done it? However, it begs the question that where there is the first instance of a dual-use satellite system being used to provide directly support services to one belligerent country, and the Russians said that this is a legitimate target, you must start looking at everything in context to the military use of outer space, the laws of armed conflict. And because there is no international agreement on the military use of outer space, for obvious reasons, of course, there is an increasing inclination to try and find meaning, to try and find a way of applying laws of armed conflict. You're talking of jus ad bellum, in context to outer space and how we are behaving. These are very many questions. I don't want to take up any more of your life, but just to say that you need to apply your mind to it. Application is cardinal, irrespective of whether you decide or choose to take a profession in academics, in which case you must be that authority which is being quoted internationally. Isn't it? International Court of Justice allows that as evidence, doesn't it? Opinio juris. And you have to be able to provide India the necessary advice in the years to come. Starting now, we are going to need it. So it is you on whom we shall depend. We've been there and done that, and we will assist you in which way we can as you progress. But you must take that initiative on the academic front. Thank you very much.
Thank you so much, ma'am, for your valuable words. Now I invite Mr. Ashok GV, sir, advocate and partner, Factum Law. Sir represents clients in the technology, food and beverage, construction and media, and a variety of disputes involving tax, intellectual property, real estate, and alternative dispute resolution forums. With a keen interest in research, publication, and teaching, he has also written, published, and delivered talks in international and domestic journals and fora, including law schools, engineering colleges, judicial academies, police training centers, conferences, and seminars. I'm privileged to invite Ashok GV, sir, for the felicitation speech. Sir, please.
Thank you. I just want to share my screen. Can everybody see the screen?
Yes, sir.
Perfect. So first of all, many thanks to Kerala Law Academy for providing me this platform. And let me at the very outset admit that I'm uniquely underqualified in this panel. I think people who are far more qualified, more knowledgeable, and more experienced have already spoken before me. So I'm going to try and keep my presentation focused on the experience that I have working with startups and businesses in the space sector, and what their insights are, or what their experiences are in terms of how space law affects them. So what I will also do is to try and take this opportunity to open up a few questions on some of the really far off questions that space law will have to answer. But these conversations have already started, and I think it's important that we don't get left behind in deliberating some of those questions and the answers to them. So without further delay, let me just quickly get to the first point. I think the context and challenges have been highlighted over and over. But I think the point that I would like to make is that the traditional approach has been to look at space activities as falling within clear silos. You have commercial activities, you have sovereign activities, you have people attempting to use space for advancing military activities on the ground. And all of this was seen as operating in separate domains. But I think as was the case of the Starlink case study that Ranjana ma'am brought out, those worlds are converging. They're no longer in silos. Political, military, commerce, business, they're all now increasingly interacting with one another, raising new questions. And I think that's the challenge that has come to us as advisors to businesses. What does it mean to them when, say, a Starlink works with a Ukrainian government, and Russia decides that it's okay to target the satellites in the course of a military conflict. So these are questions that don't really have easy answers for us, and I think that's something that we would increasingly look to the scholars out there to help us figure out in the days to come. The next thing I think has been that the original space race was a byproduct of the Cold War. It was a clear competition between the Soviets and the Americans to see who will do the maximum in space, who will do it the fastest, and who will do it the best. And I think in between, due to the collapse of the Soviet Union, we did see some level of tempering down of the sentiment. But I think we are now going back to that scenario, as is seen by the Artemis Accord, which America very famously claims to be rooted in the Outer Space Treaty. But at the same time, there are words used there, such as safety zones, heritage sites, which really call into question as to how the principles of non-appropriation under the Outer Space Treaty is going to be applied and acted out by some of these global powers. And even as America is looking at the Artemis Accord, the Soviets and the Chinese have already come back with their own initiative to set up a lunar base. So it is going to definitely get a little competitive between these two world powers. And I think, fortunately or unfortunately, they're going back to the Americo-Soviet narrative around space. And I think that's something that we have to collectively deliberate about, considering that India has had a history of non-alignment. The challenge for us as space law practitioners who work with emerging startups is that there is so little said in the law. I mean, there is such room for interpretation in the Outer Space Treaty. Different nations have taken different views on the subject. For example, notwithstanding whatever is stated in the Outer Space Treaty, the Americans are convinced that it does not come in the way of them granting licenses for asteroid mining. So if I'm a business that is looking to mine the same asteroid for which another company in the US has already received a license from the US government, what happens? Who gets access to that particular piece of, for the lack of a better word, real estate in space? And I think these are some areas which the laws are not very clear about. And I think we can deliberate the different perspectives under international law, but we will still not get that Hail Mary or that one little sweet piece of legal advice that will effectively resolve the question. And I think the other thing that's also happening is that there's a lot of silence among nations. As I will demonstrate with some of the new emerging trends in international space activities. Nations are not talking to each other as much as you would have liked them to when they're coordinating their space activities in terms of what they're launching, what is the purpose of that mission, what it means for the overall activities of the rival nation. There isn't enough communication. And when nations don't speak, it creates a tense atmosphere, and tense atmosphere is a bad idea for everybody, including those people who are not directly involved in the conflict. And I think this is something that businesses who are looking to do space activities will have to increasingly be mindful of. And the paradox is that, as you yourself saw in the panel and the speakers who came before me, we have no dearth of scholarly expertise in this country, or globally for that matter. There is tremendous amount of knowledge, there is tremendous amount of wisdom, there is tremendous amount of excellent peer-reviewed publications coming out of India, coming out of the world. But it still hasn't translated to a predictable and certain regulatory atmosphere for the businesses that we are working with. And there is a reason for that, because like how the different domains of space activities worked in silos, I think even in terms of the various professionals who are involved in space activities, be it the academia, be it the people in the decision-making powers of the government, be it people who are practicing space law, there just isn't enough interaction among them to actually resolve some of the problems around the uncertain regulatory atmosphere. And the challenge for space lawyers who are working with the industry is to try and provide the clarity that the business is looking for as they step into increasingly niche and novel areas of space activities. And I think that's where things become very challenging, but also becomes very interesting for us. Okay, so let's look at some of the political factors that affect business for a spacefaring, company, right? So let's look at a scenario, for example, where I'm setting up a small satellite company that's going to do some quantum communication related work in space. And I'm looking to set up a low Earth orbit constellation for that. Now, I need to raise investments. And what I realize is that perhaps sitting in India for something as radical and as something as novel, raising investments in India might be a little challenging. So why not look at Silicon Valley as an express option in the US? Now I go there and I set up in my company in the US, and I have I get access to my investments. I raise my first round of Series A funding, but I'm also now having to deal with an entirely different beast, which is the export control mechanisms of the United States government, which can be extremely regimented and extremely problematic for a business that is looking to also say do a lot of export business outside of the US. Right? Because suddenly now the amount of trade compliances you have to undertake, the amount of oversight that you have to answer to, your entire freedom of business has now got an altogether new regulation affecting you, which is the US export control regulations. At the same time, if, for example, I am looking to develop technologies that can launch rockets faster, and they could perhaps have some defense implications and perhaps attract some some kind of sanctions in the international regime, or requires a lot of waivers and navigation in the international legal regime. If I partner with a country that is part of the permanent member of the UN Security Council, chances are that that nation will be able to get me my waivers, get me my international legal approvals much faster, as opposed to doing business with a country that does not have that kind of clout in the international political scene. So today, a simple case study is that if I'm a country that is looking to decide between buying the JF-17 fighter jet from China or the LCF from India, China can represent certain political advantages because they can use their clout in the United Nations to get me access to, say, advanced air-to-air missiles or advanced air-to-ground missiles, which may be not as easy if I work with the Indian government, though the technology is superior. And this is a dynamic that will increasingly determine a lot of things when it comes to business in the space sector. The Artemis Accord and Sino-Russia moon base is a development that's attracted a lot of attention and debate among legal circles. But what does it mean for a country that does not choose to side with either party, right? And what happens if they decide to piece up the moon between themselves and say, I own this part and you own this part and will not interfere with each other? So I think this is a lot of food for thought for businesses that are looking to say mine the helium-3 element on moon, or where do they set up? Do they set up in the US? Do they set up closer to China? Or do they remain neutral? This is something that's going to have a lot of bearing, especially with the prospective efforts to set up colonies for purposes of mining resources, because that has a commercial implication, and a commercial implication invariably, as history of colonialism shows, what starts off as a trade initiative becomes a sovereign colony eventually. That's the English East India Company and India becoming part of the British Empire subsequently. So that's something that businesses will have to be increasingly mindful of, and so will regulators. There is an urgent need to redefine the US-Russia narrative. I think it's dominated space activities. Countries like India, which probably are quite keen on maintaining their diplomatic independence, especially something that was tested during the Russia-Ukraine conflict, unless and until we are looking at consciously redefining the US-Russia narrative and asserting the principle sacrosanct to the Outer Space Treaty, the atmosphere for commerce is going to get increasingly more difficult, more complicated, less certain, and less predictable. And the next part is very important. What is not said will get interpreted. Now take a look at the Russian inspector satellites. What is the true intent and purpose? Russia tends to be very guarded about it. And US is very convinced that it has military applications and intent. Now, does that make it a weapon in space and thus a violation of established principles of space law? It's a big question mark. And what is the dispute resolution mechanism to address that? We still don't have answers to a lot of this. And what this means is that tomorrow, let's assume that a stray piece of satellite ends up colliding with the International Space Station, perhaps causes damage to some property or maybe even loss of life. We will have that active question as to whether it was debris, whether it was a conscious weapon. because currently there just isn't enough communication between nations in resolving some of these questions. And that can also mean that my satellite in space, if I lose control, the ramifications or the repercussions of that in case it results in some damage could be much more than just financial. It could lead to serious political conflicts. It can lead to serious diplomatic fallouts. Now, that also means that nations will tend to get more and more guarded in terms of allowing private sector businesses to step into space, or perhaps do the exact opposite just to achieve some kind of a disruptive effect. So this is something that I think we have to be extremely mindful of when we advise our clients who are looking to get into this domain. And last but not the least, I think from the perspective of this constant tussle between should the space activities be driven by the nation, should it be driven by private businesses, I think the answer is both, because if we have to maintain our resource security in space, especially when it comes to things like helium-3 or lithium-ion and so many other resources that we're likely to look at space for, without compromising our independence and neutrality and the ability to take decisions and stands independently, technology independence is absolutely critical. And technology independence will not happen unless and until policy takes lead. It enables it by ensuring that there is a proper legal framework for nations and businesses to work together so that Indian technology independence can be asserted through the best possible means and the best of talent and the best of ideas work together. And unless and until this becomes a part of a space law objective, we will always not realize the full potential that the Indian space program has to offer. Now, coming back to the convergence stories, like for example, the cyber attacks against Viasat satellites during the Russia-Ukraine conflict. There is a big question as to what happens if there is a harm done to that satellite, if there's a permanent loss of functionality. Do we then go back to the liability convention and then say, okay, let us look at the issue of compensation? Or do we look at international humanitarian law that says if there is a non-state actor who is involved in the hostilities, then it is justifiable to target those resources involved and as part of a military conflict, and there is no liability that follows. Which one will actually make the determination? This is heavily debated, this is heavily publicized in terms of publications, but at the end of the day, there is no clear answer. And I think that is something that you have to factor in. If, for example, a client comes and says that we have been contacted by Ukraine for satellite images to be provided on the Russia-Ukraine border front, but we are scared that if we provide those images to Ukraine, Russia could knock out our satellite. What do we do in terms of building indemnities with our agreement with Ukraine? Are we going to ask for sufficient indemnity to be given to us in case Russia knocks us out? Or do we have to procure insurance? Does our insurance policy cover attacks during military conflict by, say, Russia? All these questions are something that we will have to answer for our clients, especially it is no longer open to us to say that that is not part of our job as commercial space lawyers. We have to now be thinking, multidimensionally on all these aspects. Things like state responsibility in a cyber attack. Cyber attacks, whether it is terrestrial or directed towards an asset in space, a lot of times it's carried out by non-state actors, and the legal challenge remains attributing it to the state. Because typically the burdens of state responsibility, the burden of proof for state responsibility is ridiculously high. So when a bank is attacked by, say, hackers associated with the North Korean government, to attribute it to North Korea as a state is extremely difficult. But space law also says that the state is responsible for the actions of the non-state actor. So does the cyber attack against the satellite qualify as a space activity? If yes, can we then have a reduced burden of proof for state responsibility? These are questions that we will have to increasingly look at, especially if we have to advise our clients who are in the receiving end of some of these cyber attacks, what the legal options are. The next thing that we will notice is that political conflict has the immediate business fallout. So when the sanctions against Russia followed the Russia-Ukraine conflict, one of the immediate consequences was that the launch of OneWeb satellites on Russian launch vehicles immediately had to change course. Now, this also means that when you're advising, say, a OneWeb, you have to constantly keep abreast of some of these political developments and military developments and see what ramifications it has on your client. And if you cannot do that, then it essentially means that you're falling short of some of the advice that you should be giving. Last but not the least, smaller nations, which were otherwise in terms of size and the strength of armies not very relevant, are now using the vehicle of liberalized space regime to offset some of their disadvantages. So Luxembourg, for example, which is perhaps the size of my city in Bangalore, can perhaps become one of the most important spacefaring nations simply because of the amount of time effort that they're putting into setting up a fund for asteroid mining. Isle of Man with its space regime is being touted as the next model space regime for commercial space activities. These are nations that you wouldn't have heard of. But unless and until you're following these developments, you will never be able to advise your clients where to set up and what policies to take advantage of if you are ever going to step into the domain of space activities. So today, if you're an Indian business looking to do asteroid mining, perhaps the best place to be is in Luxembourg. So these are some things that you as space law students and practitioners will have to constantly be abreast of as you go towards the future of advising your clients on what kind of queries they might have. Now, coming to the domestic space law. Now, we've understood the changing environment of the changing political and technology environment dealing with space. Now, how do we address this as a domestic space law, as the domestic space law is yet to come forward? We have to address mistakes of the past. Predictability, which was lacking, was a problem. We never factored in trade law and bilateral investment treaties when we took decisions on, say, the Antiques Devas or the 2G spectrum scandal. So today, those are costing us heavily in terms of international arbitration for BIT violations. DOT, DOS, where the jurisdiction of one begins, where the jurisdiction of the other ends. Big question mark, lot of confusion. The history of the Antiques Devas will clearly tell you that the decision to cancel the spectrum, the project with Devas was not taken by any single entity. In fact, it was different agencies of the government had different reasons for it. And that was one of the reasons why the ultimate arbitration went against us. So these are some mistakes of the past that we have to really address going forward. We need to understand and appreciate that technology independence will be critical to our non-alignment in the US-Russia narrative going forward. And technology independence cannot happen unless industry and the state work collaboratively, work together, and don't become competitive with one another. So how policy will make that happen is going to be very important. And last but not the least, and this is something that I very strongly believe in, we are talking about Atmanirbhar Bharat was about technology leadership, being ahead of the technology curve, creating innovation within the country. But why are we not being Atmanirbhar or self-reliant when it comes to policy initiatives? You saw the quality of speakers that you had before I started my session. Why are we not initiating our own Vilamos? Why are we not initiating our own Wumeras? Why is it that talent manual comes from a university abroad and does not come from a university within the country? Why are we not leading policy initiatives? Why are we not being the policy innovators? And I think this is something that all of us collectively have to take responsibility for. We have to create that space where our academics, our space law practitioners are at the forefront of the next development in space law. And we don't wait for Western manuals and Western thinkers to lead the way and for us to follow. And last but not the least, this is absolutely important. Responsible behavior in space, especially when it comes to space debris, which is a huge problem. What is the policy support we're going to provide? Are we going to provide tax incentives for businesses that are looking to solve the problem of space debris? Are we looking to create a better investment atmosphere for them? Will the state guarantee purchase contracts for some of these businesses that are looking to do that are looking to do activities that are critical to the sustainability of space, but may not be seen as commercially relevant or market friendly? And that is where space policy has to come in and say that what market opportunities will not provide to you, we as the state will become that market opportunity for you. Today, a SpaceX success story would not be possible if not for the government contracts that made it possible. India, for it to bring its own versions of SpaceX's, state support for not just cool space activities, but even some of these troublesome areas like space debris is absolutely critical. Unless and until we do that, innovation in these areas that will probably have the most critical bearing on space activities will not happen unless and until the state steps in. So how do we solve this problem? Now, let us look at the lack of convergence as a problem. Today, the conversation on the draft space law unfortunately only looks at the commercial angle, but we are completely divesting ourselves from the military aspects of commercial space activities. One of the, there was a very nice book by General Malik on the Kargil war, what went wrong and what went right and how the war was won. And one of the things that he says, which actually startled me, is that we did not have access to critical satellite imagery of positions in the area of conflict. And we had to buy it at a premium from an international source. When we had such a robust space program, the fact that we had to depend on external sources to supply satellite imagery, that too by paying a premium, it is a serious national security threat. And we can address that by having a commercial space ecosystem within the country that can fulfill the demands of the Indian Armed Forces. So why are we looking at military and commerce as two independent silos and not looking at it as part of the same problem statement? S-band, another area where the space agency took the decision to part with S-band for the Devas project, but S-band was needed for our disaster management, our military space military activities, and therefore it was felt that the allocation to Devas was not correct. One of the grounds being national security and national interest. If we do not understand the lessons from this and realize that they're all interconnected and should be part of the same approach to domestic space law, we are going to make the same mistake. So we have to realize that working in silos on these subjects is no longer an option. Industry and academia. I think one of the misfortunes about the Indian the legal environment is that if you look at an IIMB or an IIT, there is a very, very robust industry, academia, collaboration and partnership that constantly works together. Today, professors in IIM Bangalore are actively working with businesses to solve supply chain problems, to solve other business problems. Why are we not seeing the same relationship between businesses and, say, law schools, between law firms and law schools, between the state law firms and law schools? We are not doing this, and because of that, I think the scholarly expertise that you heard in the session is being underutilized and undervalued. And I think that is something that we need to urgently change. The second thing is that I think we're not asking the specific questions that we need to answer from people who can answer them. Our conversations have been so generic. What should the space law be about? I think the questions need to become more specific. How do we address the problem of space debris through a domestic space law? Should we have specific tax-friendly systems? Should we have investment-friendly mechanisms built into a space law? The more specific our questions, the more useful the answers we're going to get. And I think one of the reasons why we have underutilized our significant policy resources that we have within the country is because the persons who are posing the questions perhaps don't have the background. Law and policy cannot be driven only by technocrats. It has to be driven by a multidisciplinary team. And when the technocrats who probably don't have the full appreciation of the policy problem statements ask the questions, they may not ask all the relevant questions to the academia, to the industry, to the space law practitioners. So I think this is something that we need to also urgently address. Last but not the least, I think India has this nasty tendency of over-regulating. The last version of the draft space law, for example, had offenses, like, for example, polluting in space. But if, for example, we do translate that into a legislation tomorrow and somebody does pollute space, who is going to investigate it? Our police is not able to investigate conventional crimes like murder. Our sexual assault conviction statistics stand at 24%. Do we honestly expect people to investigate criminal liability for activities in space? And I think these are areas where foreign countries are far more realistic. They perhaps will not criminalize it, but they will look at another mechanism of, say, compensation or penalties, non-criminal consequences. And because of that, they'll become more lucrative as destinations for innovative space businesses. So I think we need to recognize and acknowledge the limitations of regulation and work within a realistic framework. We end up over-regulating, it will not work, and it will drive the next big brain drain when it comes to space activities. Last but not the least, I think India has no shortage of ability when it comes to crafting the perfect space law. I think what we lack is the imagination to make it happen by connecting all these dots. If we can solve that problem, I think that's half the battle won already. So this last bit, I think I just want to leave a few thoughts for your imagination, because the reason why I love space law is I grew up watching Star Trek Voyager, or currently I'm watching For All Mankind. And what you see as science fiction, I think that becomes relevant for us as lawyers. And I think this is the only area which allows our imagination to really take root. So here are some of the questions that people are already talking about, and we must look at now how do we address it. What if the next moon colony declares its independence? What will the constitution of the colony look like? And fact of the matter is, I had an opportunity to interact with Yale University students on this, and they're actively working on this as a project. So I think it's important that our law schools and our law students also become that imaginative. Real estate disputes, Artemis Accord refers to safety zones, protection of heritage sites. Is that just an indirect way of appropriating territory on the moon? How do we then address this next big colonization initiative that might start? And the big question, if tomorrow there's a legal regime governing all of this, because weapons are not allowed in space, how do you enforce a law on the moon, especially when it comes to principles of non-appropriation? When you're not allowed to carry any weapons, there is going to be no policeman with a weapon there. So will the conflict resolution mechanisms happen on Earth? If so, how do we enforce it? How do we drive across that behavior? I think there's going to be some of the conversations for the future. And last but not the least, there is a wonderful book called The Case Against Reality by Professor Donald Hoffman. And one of the points that he makes, which I think is very relevant for us lawyers, is he talks about the influence of phenotypes in terms of how we view the concept of survival. Today, mankind knows survival based on the experience of evolving on Earth, on conditions on Earth. And that instinct of survival is what helps us to generate the doctrine of the standard of duty of care in tort and negligence. So tomorrow, when the environment of Earth changes to the environment of Mars, and we haven't had the time to evolve for as many years as they have evolved on Earth, can we really ensure that we develop the perfect standard of duty of care for activities on Mars or the moon? Because our entire evolutionary setup has not allowed us to imagine what it takes to survive, and therefore what the standard of duty of care on Mars or moon has to be. And I think this is something that we will have to fundamentally revisit. Today, life as we understand is carbon-based, but it may not be the same in some other part of the galaxy, where it could be silicon-based life. So what does murder in, say, a different galaxy mean? So I think these are some questions that really fire your imagination, and I would urge and invite all of you to think about this as part of a fun activity. But essentially, space law is the place where you can set your imagination on fire. And it's the place where you can merge the past, present, and the future in one seamless conversation. No other area of law will permit you to do that. And that, if any, is, I think, your best incentive to step into this field. So with that, I come to an end with my presentation. Thank you so much. And hopefully these interactions will continue in the future. Thank you.
Thank you so much, sir, for your words of wisdom. Gratitude is the fairest blossom which springs from the soul. Every celebration is an experience as the external fades away and the internal lingers and echoes in the most depths of our heart. We are reminded that events like this one are milestones on a journey of life and remind us of God's fidelity all through. Now, it is my pleasure to invite Seren Elsa John, ma'am, Assistant Professor, Kerala Law Academy, Law College, to propose the vote of thanks. Ma'am, please.
Respected Judge, High Court of Kerala, Honorable Mr. Justice Mohammed Mustaq sir, Director of Kerala Law Academy, Nagraj sir, Principal of Kerala Law Academy, Professor Harendran sir, invited guests on the panel, Dr. Balakista Reddy, Dr. Sandeep Bhatt, Dr. Ranjana Kaul, Mr. Ashok JV, Director of Administration of Faculty and Student Affairs of Kerala Law Academy, Professor K. Anil Kumar sir, teachers, students, research scholars, members of the legal fraternity, other members of the audience, a warm and cherished morning to you all. It is a matter of pride for me to propose a vote of thanks at this inaugural session on behalf of Kerala Law Academy at its 14th International Seminar on the topic Exploring New Frontiers in Space, Law, Policy, and Property Rights. Outer space has always intrigued me. Being an astronaut was never an option I actually explored, but a lawyer I am. It's indeed exciting to explore the application and extent of laws that govern the outer space. I offer my sincere gratitude to the eminent and highly respected scholars and law professionals who've contributed their valuable insights on this very interesting and widely discussed area of space laws. It is truly an honor to have in our midst Honorable Judge, High Court of Kerala, Justice Mohammed Mustaq sir, who has shared his profound thoughts on this subject. We thank you, sir, for agreeing to be part of this seminar, for taking time out of your busy and tight schedule for delivering the inaugural address. Our heartfelt gratitude, sir. Dr. Reddy and Dr. Bhatt are two renowned academicians in the field of space law. Their research on this area is wide, well-known, and well-published. We are privileged to be part of your audience. Thank you, sirs. Thank you, professors, for sharing your knowledge with us. Dr. Ranjana Kaul is a highly respected litigator in the field of air and space law. Her knowledge on the subject and her ability to connect with the audience by discussing contemporary issues in this field has been an exciting part of this session. Thank you, ma'am. Mr. Ashok GV is a young and dynamic resource person in space law and related fields. Thank you, sir, for the detailed and engaging talk on emerging issues that need urgent attention from our part. I take this opportunity to extend my heartfelt gratitude to Advocate Nagaraj sir, Director of Kerala Law Academy and member of Bar Council of Kerala, Principal of Kerala Law Academy, Professor Harindran sir, Professor K. Anul Kumar sir, Director of Administration of Student and Faculty Affairs of Kerala Law Academy, who are the true visionaries of the Academy and have supported us every step of the way to make this international seminar possible. Thank you, dear teachers. I extend my deepest gratitude to Dr. Dakshina Saraswati for working tirelessly to make this seminar happen. Thank you, ma'am. I thank my fellow conveners, Professor Anil Kumar sir, Professor Ajita ma'am, Assistant Professor Reshma Soman, and Assistant Professor Priya MK, and student conveners Gautam Vishwam and Gokul VS, who were instrumental in planning and executing every detail. Last but most importantly, the technical team of Kerala Law Academy, the student coordinators, the teaching faculty of Kerala Law Academy, research scholars, students, law professionals who have contributed the papers, students of Kerala Law Academy and other institutions. To them, I extend my sincere gratitude for their kind attendance and cooperation. Thank you very much.
Thank you so much, ma'am, for expressing your heartfelt gratitude for this inaugural session. With that, we have come to an end of our inaugural session. On behalf of our institution, I would like to thank all the dignitaries for joining us and enlightening us with their valuable words.
I extend my heartfelt thanks to all of you for your kind cooperation and patience. Thank you, everyone. Have a wonderful day ahead. This is Manupriya Chellan, along with my co-anchors, Akshara Dian and Miri Rose Joshi, signing off. Thank you.